California Fish and Game Commission declares unlimited search authority. Law enforcement superweapon or assault on the Fourth Amendment? California Fish and Game Commissioners publicly declared that game wardens have the authority to conduct warrantless searches with no probable cause at all times in all areas of the state. Their interpretations of the statute give them greater search authority than the NSA and FBI combined. Game wardens are normally associated with patrolling hills and waterways, but officials at California Fish and Wildlife allege that Fish and Game Codes 1006 and 2012 allow unannounced searches of any residence, restaurant, office, store, shed, pool house, doghouse, or warehouse in the state. We find it hard to believe that state lawmakers authorized wildlife officers to inspect all residents and businesses with no probable cause or search warrant required.
All right.
Thank you, Commissioner. Good morning, Commissioners. Director Bonham. My name is Will O'Dyer. I've worked in law enforcement for 30 years in the state of California. I've worked very closely in a rural area with your wardens, and I've discussed this regulation with them and wanted some of their input on one of the two issues that I wanted to address. Second one is that part of the proposed regulation is a condition as of participating in falconry that we're essentially being asked to waive our Fourth Amendment rights for search and seizure. Having worked in law enforcement for a number of years, it's been always an issue that we have probable cause before we go on someone's private property, search their home, their premises, looking at their records and files. This proposed regulation allows wardens without notice to come onto our property, to inspect our facilities, to go through our records. I feel that this is something that is of great concern and may expose the department to potential civil litigation and civil liability. And a lot of our decisions in law enforcement are always predicated upon being concerned about potential liability. I think that you should direct that this provision be stricken, that if they're to inspect a facility, that it should be based on probable cause. I have no issue personally that if someone's doing something wrong and it comes to light, and those officers and wardens develop probable cause, they can get a search warrant and appropriately execute that search warrant and take appropriate legal action. But warrantless searches of our facilities without due cause and without due process, I think is a violation of Fourth Amendment rights. Thank you very much.
Thanks for those comments, but we need to clarify the point about the Fourth Amendment. As a former law enforcement officer, you should know that I think that's an inaccurate characterization of the legal authority here. When an activity is permitted, there's no probable cause needed to inspect the facilities, and in my experience, the only inspections that really matter are the ones that are unannounced.
Former Fish and Game Commissioner Sutton seems exasperated that a state law enforcement officer would dare speak in support of his fellow citizens' constitutional rights. He has since been replaced after a hailstorm of complaints regarding his motives for comments made during an online web conference organized by the largest anti-hunting organization in the nation, in which he stated, "I actually believe legal hunting that's not sustainable may be a more pervasive problem in California," astounding sportsmen and outdoor organizations throughout the state.
But Mike Carrion,
if I may, I wanted Mike to make comment here, because for those of you who may not know, our wardens do have that authorization at all times, in all areas. But Mike, why don't you comment about that?
The California Department of Fish and Wildlife staff agrees with Commissioner Rogers. In the official statement of reasons response to the concerns expressed by citizens, they cite Betchart versus Department of Fish and Game as legal precedents. However, the finding of Judge Lowe in this case does not support his claim. The judicial finding is actually posted on the California Department of Fish and Wildlife website. Hunting takes place in open fields, whether publicly or privately owned. Open field sites are regarded as a public nature, and searches are justifiable without any particular showing of cause or exigency. This hierarchy of protection arises not from the application of differing constitutional standards to various locales. but rather from an application of single standard of reasonableness to all places in accordance with fundamental understanding that a particular intrusion into one domain of human existence, such as a home, seriously threatens personal security, while the same intrusion into another domain does not.
Yeah, I understand what the the content of that as far as general law enforcement work goes, that warrants are required in order to do inspections. However, because of the public resource and the fact that if you made an announcement that you're going to come in to inspect a permitted facility, you would never know if violations were to occur. So there is a different level of authority given to wardens when in enforcing the Fish and Game Code and regulations of Title 14, specifically given under the authority of Fish and Game Code 1006. Inspection authority there is given only to wildlife officers. That does not go beyond our group so that it isn't abused for just searching for anything, but specifically to making sure that the resources are protected. So that inspection authority is given in the code.
Chief Justice Tanny Gore seems to disagree. In the 2011 Supreme Court warrantless search case of People v. McKeough, the Chief Justice determined that Fish and Game Code 1006 was not intended for the infield stops of non-commercial anglers and hunters by game wardens. The Chief Justice explains that Section 1006 is derived from the former Section 23 of the original Fish and Game Code as enacted in 1933. Former Section 23 provided in relevant part, the Commission shall inspect regularly all boats, markets, stores, and other buildings except dwellings. In providing for the regular inspection of the specified locations, former Section 23 was evidently intended to authorize game wardens to conduct repeated inspections of places where fish and game were likely to be kept for sale or storage.
Yeah, I absolutely understand why a former peace officer would not understand that we had that authority, because you didn't.
The Chief Justice of the California Supreme Court has likewise concluded that Section 2012 administrative inspections by game wardens are limited to pedestrian or vehicle stops to those who are or have very recently been hunting or fishing in order to request the occupant to display fish and game caught.
Alrighty, next speaker.
Department officials claim authority under FGC 1006 in 2012, which make no reference to permits, making it unclear if the Chief Justice must be a licensed hunter or fisherman for the wardens to search her home and office. So it becomes a matter of interpretation by whoever is in charge of the California Department of Fish and Wildlife at the moment. In any case, California Department of Fish and Wildlife officials claim search authority is given only to wildlife officers and not general law enforcement efforts, as if violating citizens' Fourth Amendment rights is not an abuse when done under the pretext of wildlife management. Sportsmen may view this as another step in the animal rights extremists' final solution to end hunting and fishing in the state. More alarming, however, is that any armed law enforcement agency with limitless power is an insidious threat to personal security of every citizen of California. This message has been brought to you by the American Falconry Conservancy, who believes that the Constitution and wildlife management are not in conflict with one another. The conflicts arise when administrative agencies overstep their authority to regulate and create law, which is the responsibility of the legislator.